morning, everyone. I hope you can hear me correctly. No.
There's some noise.
So I'm asking the, perhaps close the door, yes. And also the microphone people.
Ooh, my microphone's working.
Okay, what about mine? Is it better now? Yes,
Yeah.
super. So, good morning. For 5 minutes yet, welcome to this panel dedicated to the theme of standardization of AI. I know that some of you already had a good introduction in the previous one, and we hope we will complement the information you've been receiving, and we are going to focus on new governance and inclusiveness in AI standardization. My name is Chiara Giovannini. I am the Deputy Director General of ANEC. ANEC is the association representing consumers in standardization. I am delighted to be accompanied and joined by a distinguished panel of speakers. It is my pleasure to share with them the discussions on this important issue as well as with you. So let me introduce the panel. On my right hand, we have Thierry Boulanger from the European Commission, the Deputy Head of Unit in charge of artificial intelligence policy. Welcome, Thierry.
Thank you. Thanks for having me.
Also on my right side, we have Natalia Giorgi from ETUC. ETUC is the organization representing workers and trade unions in standardization. Natalia will explain later the impact that the workers are having in standardization. And on my left side, I have Emilia Tanter, and Emilia is from SBS, the organization representing small businesses in standardization, and she's also the chair of the working group 2 of the technical committee, the joint technical committee doing the work on standardization. Welcome, Emilia. And online, I would like to perhaps have the
He's there.
connection. Okay, so I don't see you directly, Sebastian, but welcome. Again, I think you've been connected in the previous session, and Sebastian Allensleben is the chair of the CEN and CENELEC Joint Technical Committee 21 dealing with AI. Why are we going to discuss AI standardization and especially the inclusiveness in standardization? Again, you might have heard it before, the standards are going to play a key role in the implementation of the AI Act. We are going to deal with standards for providing presumption of conformity with the legal requirements on AI high-risk systems. Those standards have been requested by the European Commission to 2 of the European standardization organizations, CEN and CENELEC. They are being drafted. ANEC is participating to the drafting, and this is also thanks to a special funding we are receiving from the AI Fund and the Mercator Foundation. This is why we are here as well. We are not the only ones, but who is really around the table? How inclusive is the system? And how are standards contributing to the governance on AI? The theme of today's conference, of the 3 days conference, is to govern or be governed. We are going to see where standards stand to this regard. And also we would like to provide you with some insights and discuss about how inclusive is the process and what can be done or shouldn't be done. Now I'm going to start the panel, so I will leave the floor to our first panelist, Thierry. We are going to start with the first question. How high a priority is inclusiveness in the governance of AI standardization, and what does it mean to you, inclusiveness?
Thank you, Chiara. So good afternoon. Now I think it is time. Thanks again for having me here and so having the possibility to engage and participate in this panel. So I will start with a short answer before I end with a 5 minutes limit. So the short answer is it's a very high priority for us, inclusiveness. Now maybe just to elaborate a bit and starting with some background, I understand the question of the approach of the NLF approach taken in the AI Act and the raw standards was already discussed in the previous session, but still. So I wanted obviously to start by mentioning the fact that now, I mean, with the final green light given by the Council earlier this week, we are about to conclude in the coming days what has been quite a long marathon on the development and the negotiation of the AI Act. I mean, this started, depending on when you want to consider the start point, 3 to 6 years ago. I mean, 6 years if we take the moment when the Commission first started to work on AI as a real policy issue, I mean, beyond support to research and innovation. But so this is a very happy moment, but this is also just the beginning of a new phase. Now we have to work, and we are working very seriously on what comes next, which is the implementation. So this includes setting up all the governance structures which will be required to ensure proper and effective implementation of the Act. This includes a number of implementing acts which will have to be developed in the coming months, I mean, to further specify, provide further guidance on the way the Act should be implemented. And this also includes the very important work on standards. So you refer to the key importance of standards for the implementation of the AI Act, in particular for what concerns the obligations which are being introduced for systems considered as posing high risk to safety, health, and fundamental rights. This is so important, and it's such a challenging task that we actually did not wait for the adoption of the Act to work on this. We engaged very early on with standardization organizations to, first assess what was already available and also start prepare the work. This became a bit more formal last year when we issued what we call a preliminary standardization request, so a formal request to European standardization organizations, so CEN and CENELEC in particular, to develop these standards which will reflect technical level the way the obligations of the AI Act could be implemented. It's not, I mean, it's a way for providers to get presumption of conformity. It's not, but I mean, it's not mandatory, but still, it's very important mean to guide, to foster the implementation of the standard. Maybe a few words on the why we took this approach. I mean, so there are challenges, and we'll discuss this, I guess, in any case later. But I also want to stress the advantages of this NLF approach, which we decided to take for this part of the regulation. So AI, obviously, it's a very technical area. It's a fast evolving area, and so in that context, it does make sense to us to rely on the structure which exists with standardization bodies and the standardization process, which involves consensus, which involves the participations of various experts representing different types of interest and areas of expertise. So this is something, I mean, we thought as essential with a view of specifying in technical terms how one could comply with the obligations introduced in the Act. Then, now on the question of the inclusiveness, I mean, and also linking to what I just said, yes, of course, in that inclusiveness is essential if you want to achieve this. So you do need to make sure that in the process, all types of stakeholders concerned or who have expertise which is valuable to carry this work can be so that we can benefit from such expertise. This does not only concern the case of the AI Act. I mean, if you look at the EU regulation on standardization, I mean, you have dedicated provisions on stressing the importance of the involvement of stakeholders in the process. There is also funding which is provided to stakeholders organizations. We have also various instruments, complementing this funding. The importance of the involvement of stakeholders was also recalled in the EU strategy on standardization, which was adopted in 2022, and which also called for further efforts from standardization organizations on this very important issue. So now, I mean, today, I mean, back to the case of the AI Act, we are, to a large extent, relying on all these elements, so the funding, this action supporting participation of stakeholders, in particular at international level. In the structure which has been put in place by CEN and CENELEC to develop these standards, you have a specific task group working on this. Also, and you, well, this is still an open question, and we can certainly, I mean, we are discussing how to do better, but a number of organizations, so in addition to ANEC and ETUC, are actively participating in this work. But we are still working, in particular with CEN and CENELEC, on how to go beyond that. We've been having a number of discussions on this, well, for quite a while, I would say. We recently issued a grant to CEN and CENELEC to provide yet more funding, more support for the participation of stakeholders in this work. I mean, those for whom it might be more difficult than others. We are also having discussions on how to foster more transparency, more inclusiveness, including for organizations who might not be able to participate directly in this work. And I will conclude with this to respect the time, and that's also why I'm here today. So as part of these discussions, we are also having as to how to make sure that we do deliver on this. Well, something important, sorry, I forgot to mention, in the mandate which was issued last year, the need to ensure proper involvement of stakeholders of all types, including SMEs, representatives of civil society. I mean, it's something which was which was emphasized, made very explicit in several places. In the main part of the mandate, also in the part outlining how the work should be organized. So just to again reaffirm our commitment to do whatever it takes to deliver on this. And I will stop here for now.
Thank you very much. Whatever it takes. Wow, these stakes are very high if we have to, reference to other sectors and other precedents. Anyhow, Natalia, yes. From a worker's point of view, on a scale from 1 to 5, how inclusive is the system and why?
Thank you. Thank you very much. Good afternoon. I would also like to thank ANEC for having invited me to this panel today. So to that question, Chiara, I don't think I can give a specific number, unfortunately. It's difficult to assess what could actually be considered 5 on 5 or 4 on 5. But what I can say for certain is that there was progress made and that the participation has widened to include today a larger number of stakeholders. So I thought I would, in my intervention, go through sort of the 3 steps of inclusiveness in AI standardization, starting with what was just mentioned, the standardization request, which mandates for the participation of all relevant stakeholders, including trade unions. So this is the question really, who's at the table developing the standards? And then briefly go through some of the means that were put in place to facilitate this participation. And finally, briefly, because I just have 5 minutes, go through the challenges to this participation. So as it was just stressed by Thierry, the standardization request mandates that the public interest takes a prominent role in the development of standards for AI. So the importance of inclusiveness was just mentioned. I will not go through it, but it's the starting point, because if we want to have standards that work for society, we need to have all of the impacted people present at the table. So it is the starting point. Again, if we want to facilitate the development of trustworthy AI technologies, and if we want to build trust in those technologies, we need to have standards that reflect the different interests and the different priorities of society. And I'd like to stress that this is all the more important when we have standards that are used to support legislation in public interest. So in the public interest, it's crucial to ensure that the public interest is taken into account. Now, that being said, I think there was a need to reach out to participants, to reach out to stakeholders, and to raise awareness first on the importance of standards. Because I don't think it was very clear from the beginning that standards would play a crucial role in the implementation of the AI Act, in the overall regulatory framework for AI. And also to raise awareness on the importance of engaging in AI standardization, which takes me to the second point I wanted to raise, the different means that were put in place to facilitate this participation of all relevant stakeholders. So the ETUC, the European Trade Union Confederation, helped, together with ANEC and SBS, set up, and it was mentioned briefly by Thierry, a dedicated task group on inclusiveness in the European Technical Committee Developing Standards for AI, so the famous JTC 21. And the objectives of this specific group was first to assess the engagement of different stakeholders in the development of the standards, and then reflect on ways to maybe increase their participation. And to my knowledge, it was the first time such a group was created in a technical committee. One of the practical means put in place by this task group was to share updated information on AI standardization and related activities to all interested stakeholders through the publication of a regular newsletter. It's published every 2 months, and its subscription has increased steadily since the first edition. So there are a number of measures. I only have 5 minutes, and this panel today is one example. But it's worth reflecting on the impact of these measures and where we are now. So I have to say, and as I mentioned at the very beginning, that the representation has widened since the beginning of the work in JTC 21. I checked just yesterday to make sure I gave you the updated information. So the organization, so who's at the table again, Chiara? So all the organizations designated by the European Commission to represent societal stakeholders in the standardization. So it's ANEC for consumers, ECOS, who are not here, but it's for the environmental interest, ETUC for trade unions. We're all in JTC 21, together with SBS for SMEs. And I think, again, this is the first in a technical committee. We also have, of course, the European institutions with the Commission, with the JRC, ENISA, who are also participating in the technical committees, a number of NGOs with relevant expertise in fundamental rights, including children's rights, and quite a number of experts coming from academia and research bodies, essentially participating through the national delegations. So, but participation is just a first step. The truth is, and I will finish with this, it can be challenging for stakeholders, and especially stakeholders who are not familiar with standardization, to get engaged in the activities. Some of the NGOs that joined JTC 21 had never participated in standardization before. So, of course, it's a learning curve, but it's a learning curve that needs to happen very quickly, considering the short deadlines that we have. So it was mentioned in the previous panel, but we need to provide the standards by Q4 of 2025. So this is another important challenge, the tight deadlines, because the pace of the work is quite intense. It's actually practically a full-time job. And the truth is that most of the non-private stakeholders don't have the resources to follow the pace. And these are just some of the challenges, essentially at European level. There are more at national level, and I'm happy to come back to them if you have questions and if time allows. Thank you very much.
Thank you very much, Natalia. So we heard from the Commission that inclusiveness is important. We heard from Natalia that it's happening. We also heard the difference between participation and effective participation. Sebastian, as the chair of the Joint Technical Committee on AI, Joint Technical Committee 21, Which other actions about inclusiveness have been taken, and especially what are the plans for the future? Which other actions are planned for the future? Sebastian, you have 5 minutes. I don't see you directly, but all the audience can see you.
Yeah, apologies for kind of weirdly hovering over all of you. Natalia has already outlined many of the existing actions for inclusiveness, and it's also great to see, I think this is the first ever panel that I'm on, where all 3 Annex 3 organizations contributing to JTC 21 are in the same panel at the table, and so thank you again for Annick for pulling us together as in this group. So building on Natalia's remarks, it is indeed the case that in the composition of JTC 21, we are probably broader and more inclusive than most other standardization committees. That's not a particular sign of excellence, it's just a reflection of AI affecting such a broad spectrum of stakeholders. So it's kind of, this really should be the baseline, but I think as far as the composition is concerned, we've reached that baseline at the European level. There is a caveat here because the final voting on standards is being taken at the national level in the national mirror committees. And we've currently got 24, 25 national mirror committees involved in the work of JTC 21. And of course, the inclusiveness of all those committees is a different matter that varies quite a bit from country to country. I'd also like to build on the point of hurdles for newcomers, in particular newcomers who are not familiar with the complex rules and structures of standardization. There is a field guide that we're currently putting together.
Sebastian, sorry to bother you, but we don't hear you very well, so I don't know whether it's a question of microphone yourself, you can speak closer, or perhaps the technical people here can increase your volume.
We have the same issue in the previous panel, and the technical people worked some magic in the background, so maybe they can work the magic again.
So could you have a second magic, technical people? Anyhow, if you would like to continue and raise a bit your voice, although I know it's your second hour.
Okay, I will just try to speak up.
So, that's much better.
Yes, so building on Natalia's point that there are quite a few hurdles for newcomers who are familiar with the complex processes and structures of standardization before. We are in the process of creating a field guide that is designed as an entry point, as a first outline. And I know that some of the national committees are also developing primers or adapting their existing primers to AI standardization. Having said all that, there are certain limits or certain dilemmas that we come up against. One is surrounding transparency. I'm quite often asked by people not involved in AI standardization, well, this is this sort of slightly secretive club where people meet outside of the gaze of the public eye, and they do stuff, and that stuff then becomes sort of mandatory, and isn't this some weird backroom dealing there? And of course, it's always easy to point to the regulation and to the processes and that it's all consensus-based, but that doesn't really answer the request for transparency. And the newsletter that Natalia mentioned goes some way of trying to satisfy that interest for transparency. But at the same time, we all know that difficult discussions, in particular discussions where you fight hard for compromise, cannot be conducted particularly well if the world is watching each and every word and each and every draft statement and document. So you need some protected space, some safe space for people to have those arguments, have those constructive fights, and hopefully come out with a compromise at the other end. And therefore, there is a limit to the transparency that can be provided. Maybe it's a more broader, more fundamental discussion that affects other standardization topics as well, but this is a limit that we do come up against. Another limit that I come up against is one of expectations. So I'm quite often being approached by people or organizations with very, very specific interests. They explain to me what their interest is and what they think is really, really important, and think, well, that's job done. Because now we've told the chair that such and such needs to be considered in AI standardization, so job done. It's Sebastian's responsibility now. And that is simply not what it is about. Standardization is not the same as advocacy. It's not enough for someone to really burn for an issue to make it happen somehow magically. You do need to take that second step, and that really, really hard step of joining JTC 21 and exposing yourself to lots of people with very different opinions, very different interests, and of trying to make your argument and trying to find compromise, trying to find consensus. That is the big second step that has to come after advocacy, whatever the issue is, societal, commercial, there are also all sorts of issues there. So in conclusion, I would actually want to say that standardization, on one hand, works well if a broad range of interests is around the table because the result is better. But as soon as you have a broad range of interests around the table, the road towards those results is much harder. And I just want to manage expectations and make sure people understand that this process has to be conducted. There is no easy workaround to the animated and sometimes kind of very, very heated discussions that we're having in this committee. Thank you.
Thank you very much. So from effective participation to consensus building. And now Emilia, as a representative of SBS, but also as the convener of Working Group 2, would you like to reflect on which inclusiveness measures worked, what more can we do, but also what's going on at the international level?
Thank you, Chiara, and thank you, Annick, for the invitation. I think this is, Sebastian mentioned, Thierry and Natalia mentioned, this is the first time we have this constructive discussion. It's not the first time we are having this discussion, but we have a panel, which is a public panel. This discussion is going on for some years now, so it's not new. And I think, reiterating on Natalia's steps, we are now at the third step on this inclusiveness. We first had to assess where do we stand in terms of inclusiveness? What are the triggers that could support inclusiveness? And the European Commission supported with concrete measures. We have funding which is available for experts to participate. And then we saw the effects. We saw that in the room we are at the step 2 already. We reached impact in terms of numbers, in terms of experts which are participating. Now we are at the third step. How can we improve effective impact? And this is, of course, this is for AI, it's a difficult topic. I come from research. So I know that, Sebastian mentioned it, artificial intelligence, this umbrella term, encompasses many disciplines, encompasses research, and we have the benefit of having the Joint Research Center, which is always bringing us the solid ground truth of research. So we are really benefiting from that support, which is important support. It has this layer of social sciences, so we need to have also the civil society represented, and we need to have the consumers represented. And then we have also the application, the deployment, which is an industrial deployment. And then we go to the industrial practices, to the universe of standardization, which was previously mainly opened to industrial practice. In Europe, we have a different stance. In Luxembourg, we say, "Wir willen blijven wat wir zijn." We want to protect our European values, our ethical values, which were transposed in the first step of the application, which is the mandate in the European AI Act. So we are protecting those by providing now standards which should reflect those values according to the principles that were set in the UEA Act. We all pass from principles then to concretization, and we have the legal act and the operationalization. How do we reach this efficient EU participation? I will give an example. We have, of course, a lot of stakeholders in the room, but the ones that master the vocabulary of standardization, they will have their opinion easily accepted because we speak the same vocabulary. And there are concrete now, I could see concrete trainings. For example, HS Booster provides for experts, this is quite new, but it provides serious smiling game. How to reach impact with a smile. How to reach how your opinion as new expert could reach an impact and be included in the standardization deliverables. So you are trained in soft skills, in how to negotiate, how to position yourself. What we should remind ourselves, it's a lesson I learned as a researcher, is that the standardization process requires continuous participation, and we need effective participation. So it's not sufficient to raise the arguments, but those arguments need to be adopted, and they need to be embraced by the others. So you need to construct a compromise with others. Going a little bit on the different other aspects of inclusiveness, and I will go afterwards to the international dimension, there are other aspects of inclusiveness in the European context. In CEN and CENELEC, we are there to serve European interests. And to serve those European interests, we need to remind ourselves that the starting point is data. So this is the reason that we are here. Because we are starting standardization for an horizontal legal framework, which is already, I would not say dependent, which is already relying on other pieces of legislation. So interoperability is key, especially interoperability with all data-related legislation and cybersecurity-related legislation. Artificial intelligence treats data, and of course, as any stochastic system, has safety and security concerns. What we might see as a challenge is the perception around the standards. In Europe, we develop standards having in mind safety, fundamental human rights, and of course the risks-related aspects. So this is a particularity. Now going to the international level, of course we have international standards which are being developed even sooner than 2021 when we started in Europe. 2018, the international standards were developed. And of course, there are efforts, technical specifications, which do not have any changes if we take the European context and the international context. But then when we speak about our perception and our vision of safety or fundamental human rights, then we might agree to disagree on some aspects. So for this reason, we need to have European standards. We hear quite often that in Europe we adopt standards, which is not really the case. In Europe, according to Regulation 1025 from 2012, we are serving the European legislation, CEN, CENELEC, and ETSI, according to paragraph 5, if I remember well, they can be mandated to provide technical specifications. And then for the Vienna and the Frankfurt Agreement, CEN with ISO and CENELEC with IEC, they need to align. But we do have this European dimension that needs to be developed in supporting especially safety, fundamental human rights, and of course our dimension of risk as we perceive it in Europe according to the AI Act. And with that, I'm just taking a note. Of course, we have concrete instruments, and I think that is a huge advancement, as mentioned by Natalia previously. We have a newsletter. Now we assess with concrete instruments. We assess where we stand in our developments in terms of inclusiveness. We also have other measures that could support, for example, researchers and newcomers, like the field guide. And I think these are concrete operational steps. Thank you.
Thank you very much. We've heard what inclusiveness means, what has been done so far, what works, what doesn't work. I would like now the panel to reflect to the key question of the panel, but also of the conference. Who is governing AI standardization? Thierry, would you like to start?
Well, who is governing AI standardization? So if we refer to, because AI standardization can encompass things which go beyond what we need, strictly speaking, to implement the provisions of the AI Act, just to be clear. So, I mean, and with our ongoing discussions, notably on what can be reused from all the work which was initiated and even sometimes completed at international level, what needs to be done to complement this, I mean, to really fit the needs of the Act. So, if I limit the scope of the question to standardizations, standards to be developed to support the implementation of the AI Act, then we follow, I mean, the rules established with the regulation on standards. So basically, this is very clear about the fact that the Commission issues formal requests to European standardization organizations, and we had one which is about to be updated and which was addressed to CEN and accepted by CEN and CENELEC. We are following this work very closely because at the end of this process, these standards need to be delivered back to us, and then there will be the time to assess the extent to whether or not they do reflect in an appropriate way the provisions of the law of the AI Act, which would then allow to publish them as harmonized standards, providing the presumption of conformity with the obligations introduced for high-risk systems. And in this scheme, I also want to mention the possibility for the Parliament or member states also to object should they consider that the mission is not completed. So that's the way it works and we work. I know this answers your question.
Thank you very much. A very institutional answer, but interinstitutional answer, but this is what we expect.
Maybe? Can I have, because just you, concerning the current deadline for the mandate assigned to CEN and CENELEC, it's end of April 2025 for the moment.
Ah, yeah?
Not end 2020.
Okay.
Just for the record.
Wishful thinking then.
So, Natalia,
yes.
What is your point of view? Who is governing?
Less institutional.
Who is the boss?
Yes, thank you. Actually, who's governing AI standardization is the same question as who's governing standardization at the end of the day, because standardization system did not change now that we're developing the standards for AI. And here I have to say, it wasn't stressed before in this panel, but standardization remains a market-driven and private-led activity, largely dominated by private stakeholders who have a financial interest in participating in standardization. That is, I mean, I'm not inventing it. The independent review of the European standardization system says it, so it's a fact. Now, and it was mentioned in the first panel, which was surprising to me, but impacted stakeholders should be at the table as well. For workers, as you probably know, but all of the management functions are now more and more carried out with AI technologies, from recruitment, and it was mentioned earlier today, so discrimination during the recruitment process with algorithms discarding people with disfiguration, but AI tools are used in all of the management functions. So if we take the AI Act, the use of AI at the workplace is considered high risk. So what it means is that all the AI tools that will be used at my workplace, at your workplace, will need to follow the standards. And with the current system, if we don't, take into account the inclusiveness process, but what it means is that we're leaving the responsibility of protecting fundamental rights, which are workers' rights, in the hands of private stakeholders who are largely developing the tools for AI, which is, of course, for workers not acceptable. So, and this is why the inclusiveness element is more and more emphasized, especially for AI standardization, considering the ubiquity of the technology. I mean, it's everywhere, and it has the potential to impact many sectors. So it's a less institutional answer, but that's my answer. Thank you.
Thank you very much. I think it's an answer I like more. But Sebastian, do you agree?
Well, I would maybe combine Thierry's and Natalia's perspectives.
As the
Who is
chair,
governing?
Yeah.
Who is governing AI standardization? There are a number of different roles here, both formal and informal. There is, of course, the formal role of the European Union, not only in issuing the standardization request, but also being the gatekeeper who has the ultimate decision-making power, which standards actually receive harmonized status and become that core set of standards supporting the AI Act. And that is a very, very powerful role, and a role that is very, very helpful to balance out certain kind of disparities in available resources amongst the various stakeholder groups. But there is also a practical answer to who is governing AI standardization. It is whoever puts the time and effort and expertise in. And it is not enough to have good ideas, even if they are kind of the best ideas possible to address a particular problem. Ideas in standardization only gain traction if people are inside committees, both at the national and at the European levels, and promote those ideas and go into that, as I said earlier, compromise, consensus building kind of argument process. And so you could say, well, whoever takes the trouble to enter AI standardization is to a large extent in the driving seat, and that applies both to the technical work, but it applies also to being project editor, to actually write. Being a good technical writer is a rare skill, and people who are doing that well and who are able to capture consensus and do so in a technically significant and clear way, wield significant power, if you like, over the standards development process. Same goes for working group conveners. But that is, of course, tempered by, well, who has got the time to do so and who is being backed by an organization such as a big company who've obviously got the deepest pockets or who tend to invest the largest number of resources, or is it an NXP organization, is it a civil society organization, or is there any organization that pays the salary of someone who is spending their time in standardization? So Thierry mentioned a number of initiatives to try and level the playing field there. I think the StandICT is a important one, and one that could be strengthened even more. And ultimately, as I said, it's important to recognize that the governance processes in standardization are quite different from the process, for example, in crafting legislation or negotiating legislation. And as long as we recognize that they are two different worlds that serve different purposes and have their different strengths and weaknesses, they can be combined to maximum effect. Thank you.
Thank you very much. Listening to you, you explained holding the pen and participating, and I was wondering, you didn't say an AI system writing standards for itself, not yet. But Emilia, what do you think about AI governance? Who is governing? Who is the boss?
Thank you for this. I will just present my perspective from a small business standards. So first of all, we are serving the European interests. So the request for the main standards that we are developing now, of course, we are developing also other standards technically important, comes from the European Commission. And the European Commission has a really important role because they provide us feedback to keep on track with and be aligned with legislation. Then effectively, in the meeting, we are consensus-based. So I will just pick up from the predecessors because I align with that. We have for example, for small business standards, I'm representing 4 million companies in Europe. And that means in the international level, we are 2 representatives. At the European level, we have 1 full-time, and I'm not even full-time. So I need to invest as a company my time there. And I also have my business, so there is a compromise there. And then thinking about the small businesses' approach to standards in the consensus building, we feel really close to the consumers and the workers. Why? Because small businesses, many of them are family-owned, so they are the workers. So they feel concerned by the workers in the company. Not only because of that, but the number of clients that a small business has, it's limited. So you need to be close to the client, and culturally in Europe, you already adhere to the principle of safety and all the ethical principles which govern Europe. So for us, it's really important to work together for small businesses. This is primordial. Then, if we go in the meetings, and that was Sebastian mentioned, we have 180 registered experts and more than, let's say, 1,000 which are at the national level. How many of those are small businesses? There are initiatives which are supporting, but when you go to the voting and you have, for 4 million participants, you have 2 free votes, how much do you contribute to the governance of that process? What we aim as strategy, it was to take key roles. So, for example, I have the convenership, and I'm grateful for that. I'm just there with a neutral voice in order to support that our voice is also heard, not more than that. The consensus is built in the room with the experts. So how can we reach in the governance, in the consensus building, how can we reach effective participation and upskilling? I think upskilling, training of the experts which are present, and having also resources for key roles, full-time roles, that would be key. These are concrete instruments that operationally could support. Going further than that, I think we are all aligned with the governing principles which are given by the governance we have in place in Europe. So it's not even a question whether we replicate the model in European standards. We should have the same governance which supports the fundamental human rights, safety, risks mitigation, as we have for any other legislation. We should be aware that on the European market, we already apply those principles in the Machinery Directive and another directive, so it's not new. Thank you.
Thank you very much. We have heard from our speakers, from our panelists. I would like now to open the floor if there are any questions. I can see one hand up. The microphone is coming. If you could kindly introduce yourself and your affiliation.
Yes, of course. Thank you for the panel. My name is Mario Guglielmetti. Okay, I work for EDPS. The question is, just to know what we are talking about, concrete case, emotional recognition for recruitment. We mentioned it before. The issue of job interviews, and at workplace allowed not under the GIG directive, but under the AI Act for safety and medical reasons. And here we have to go shortly to the conclusion to know how it plays out with standards. We have to go to 3 assumptions. First, we are not speaking about snake oil, already a big assumption. Second, emotional recognition is not disproportionate and is not in breach of dignity. Second, big assumption. Since the AI Act is a regulation, of course it has to comply with primary law, the charter, and so on and so forth. Third assumption, we have to assume that the standard is the right place to regulate it or to entirely regulate it, because you mentioned that actually it's business-driven, it's a factual issue. So my question for ETUC is there any work ongoing on standards for emotional recognition at the workplace, both for recruitment and once you are recruited at the workplace? And is it possible as outcome of this work that the experts say, please, we can't just rubber stamp it because it's snake oil, it's in breach of dignity, it's against the disabilities, and so on and so forth? Thank you.
Natalia, are you happy to answer the question and mention perhaps the trustworthiness work as well?
Yes, actually, there are no standards specifically for workers or for the use of AI at the workplace. The standardization request mandates the development of 10 requirements, but if you refer to the AI Act, they're horizontal because the AI Act is horizontal. So how it works in practice is that if a big tech company wants to develop an AI for facial recognition in a specific sector, whichever sector, it needs to go back to the AI Act. Annex 3.4, workplace high risk. Then, okay, it's considered high risk according to the AI Act. I will need to follow the requirements. But the requirements are they're horizontal. So there is a requirement for robustness, for accuracy, for transparency, for risk management. But these requirements apply to all the AI systems. It's just whether or not you will need to apply that you have to go and check the annex. Do you see? Well, that's one of the groups that we have within. I'm continuing, but one of the groups that we have actually in the JTC 21, and maybe Sebastian can give more input on that, is exactly horizontal and vertical, because then you need to go check in your vertical sector which are the standards that apply to that sector as well, because the AI Act is not just coming from nowhere. It also refers to the other legislations that apply to your specific sector. So it's just really the first door, let's say, for any development of AI. I hope I answer your question.
It's not satisfactory at all.
No.
Safeguards for people, but the students can appreciate your
Whether the question is if that's enough, absolutely not. Absolutely not. But at the same time, because we had the same approach as the ETUC is actually asking for a specific directive, a European directive for the use of AI at the workplace, because standards are not enough to protect fundamental rights. We agree, of course. But if we don't have these standards, okay, providing the technical characteristics, then the use of the AI will need to do, then even if you have legal requirements, you won't have the technical characteristics, which is why the ETUC is contributing to the standards. Because if you're not saying right from the beginning what are the technical characteristics that the AI will need to have in terms of transparency, if you have a legal requirement afterwards saying, well, you need to provide proper explanations, but technically it's not feasible, then you're missing a part of it. So is it enough? No. Is it necessary? To some level, yes.
Thank you very much. And it shows the link between standards and legislations. Emilia, would you like to add? And then we take two other questions from the floor.
Thank you. I would like just to add a technical perspective. When you are mentioning emotional recognition, you have several types of data which are being used. If you are speaking about the biometrics, physiological biometrics, which is face, fingerprint, and so on, there exist standards. There is an international committee working on biometrics, and there exist standards which are intended for the usage of personal identification, for example, at border control, that exist. If we are speaking about then behavioral recognition, because behavior is another form of profiling using not physiological factors, but behavioral factors. For that, we still need to develop more detailed factors, because physiological profiling, it has technical terms, technical description. We have active shape, which can be defined. So technically, there exist ways of modeling those items. For the behavior, we need to use social sciences, and that needs, as we said, an interdisciplinary effort. So for this type of behavioral profiling, which you can find, for example, in CV monitoring and profiling through the CVs and other types of data, that is not covered yet in standardization in international level or European level. Thank you.
Thank you very much. I can see a question. Okay, and then over there. Yes, please, your name and affiliation.
Hi, Leanne Colonna from Stockholm University. I'm curious about your views on open source software, which constitutes like 90% of the software out there. OSS contributors are really integral to the security and maintenance of open source projects. Do you think that excluding them from the standard setting process can lead to gaps in compliance and security measures, as the standards may not fully address the specific needs and vulnerabilities of the open source community?
Sebastian, are you happy to take the question?
Yes, yes. There is no exclusion.
Exactly.
So standardization is, formally speaking, first of all, open to everyone. So everyone can knock on the door of their national standardization committee and invest their time and effort. Depending on the country, there is sometimes a fee, but it's not extortionate. Let's put it that way. Well, Natalia disagrees slightly, but it's sort of in the realm of feasibility. Let's put it that way. So in principle, there is no reason for open source projects and initiatives not to participate in standardization. Having said that, at the moment, we don't have anyone in JTC 21 who is, for example, representing the Linux Foundation, or who is representing the Apache Foundation or the Mozilla Foundation. So there are gaps in the representation, clearly at the European level. And if anyone's in the room from a major open source project, please do shout and come in either through the Annex 3 organizations or through a national committee. But there are no specific hurdles that would prevent open source views to be included.
Thank you very much. There is a question over there on my right side. There are two, but the ladies first, please.
Hi, thanks. My name is Sarah Brandstetter. I'm a tech reporter with MLEX here in Brussels. And I was wondering if you can give a bit more details on this field guide that was mentioned a few times now. So who is issuing it exactly, and what will it include, and when will it be published? Yeah, thanks.
I suppose, Sebastian, it's for you and Emilia? Emilia, would you?
It's actually very practical.
Okay, Sebastian, please.
Oh, sorry. Yeah, so just to make a start, so it's a very, very pragmatic document. In theory, you could say, well, it's enough to point people at the CEN CENELEC regulations. It's a whole set of bits of text that describe how standardization works, what processes, what structures work, how documents are handled. There are also agreements between the European and the international level, the so-called Frankfurt and Vienna agreement. So in theory, you could say, well, everything's contained in there. Read that, digest it, and you're set, which is, of course, in practice, not the easiest thing to do. And therefore, the field guide just aims to pick out the things that are particularly relevant for the work of JTC 21, and also to reflect some of the typical working practices that have emerged over the past 2.5 years. So, for example, things like there are many ways of triggering a new work item, but it has emerged as good practice within JTC 21 to submit a draft work item proposal ahead of the next plenary meeting, to pick up feedback during the plenary meeting, and then revise it directly afterwards, and then submit it formally. So that has just kind of emerged as useful working practice, but it's obviously not captured in the regulation, and things like that are in the field guide as well.
Thank you very much. Emilia, would you like to add? No. Additional question, the gentleman? Yeah.
Thank you very much. My name is Duško, and I'm affiliated to KU Leuven. I'm a PhD researcher there. I will have two general questions. First one, what is average time from issuing request from the Commission to the development or serving new standardization scheme? I'm asking that because recently some pieces of legislation, from adoption to enforcement, there is quite huge time span. For instance, I will take Radio Equipment Directive Delegated Act, which is adopted in 21st, and it should have been applied from 24th. However, it was delayed to 25th. At the same time, Commission issued request in 2022 as a standardization request, which should have which should be adopted by June 2024. So I don't know in which phase it is. But along this time, a lot of time passes, and deployers, developers, manufacturers, name it. I mean, they just can't wait this huge period. So basically, what is is there any average time, usual time for adoption? And the second question is related to your personal perception. Some products, systems can fall within the scope of several legislative frameworks. For instance, AI tools which are developed, or AI systems which are developed as cybersecurity tools, for instance, for protection of medical devices, let's say, or Internet of Medical Things. It's not important. They are considered as high risk by itself. And when it comes to their certification scheme or compliance with standards, we have AI Act compliance requests. Now we have Cyber Resilience Act, their own pathways, and sometimes those kind of products can fall even within the scope of Radio Equipment Directive, which has its own rules. Those rules are not per se the same, not even nor in the scope, nor in the aim, but there are some connection between those acts. But I consider it quite difficult to navigate these fast-evolving legal landscape and achieving compliance, especially from the perspective of manufacturers and, I don't know, small enterprises. What is your personal perception? Thank you.
Thierry, would you like to explain your personal experience in the question of timing and also the connections between the AI Act, the medical devices, the Cyber Resilience Act, and machinery, I would say, and how to avoid the double compliance assessment?
So we'll give it a try. So on the average time, I must say, I don't know the average time, but I know it does take time, indeed, years. And that's why we clearly did not want, as I said, to wait until the adoption of the AI Act to get this work started. That's why even before the standardization request was issued in May last year, we had already started to work with the colleagues of the JC21. I would also stress the fact that that's why we are also following very, very closely what's going on in the different working groups which have been put in place to provide guidance whenever necessary, with the objective to ensure that what we get, that the work can progress as quickly as possible, and there have been a number of challenges. This is not always easy, and also to ensure that there is no misunderstanding that what we will eventually be delivered can be used to provide the presumption of conformity. But yes, so this is a challenge. I can only say that we are on it, and on the average time, I don't know if anybody has the information.
It's about 3 years, but yeah.
Okay, so we started at least in 2022. We need them sometime next year, so it means we might. Well, there are challenges, but at least if the average is 3 years, so there is
if there is a will, there is a way.
Exactly. Then on the question of the perception, yes, this is something which was actually taken into account both in the development of the AI Act and also of the CRA. So in the AI Act, it is the case of products which are already subject to third-party conformity assessment is addressed, in a specific way. So basically, for them, the idea is to complement the existing processes in order to take into account the case of an AI system. Should it play an essential role in the functioning of this product? So it is managed in a separate way and with an approach which aims at, how to put it, not disrupting too much what is already in place and working. And in the case of the CRA, so in the CRA, this interplay is addressed indeed to avoid overlap or double certification, if you want. So this issue is addressed. That being said, admittedly, one needs to. I would not say that it's super simple and to understand for anybody who comes and all of a sudden wants to understand how the things work. But just to say that all these pieces of legislation have been developed in a way which at least strives to avoid having obligations stemming from different places.
Thank you very much. Emilia, for a small business, is it difficult to navigate?
Yes and no. For the moment, we do not navigate it because the AI Act is not in force yet. But I will just share my perspective and perception from the convener role, working with the operational aspects. So we need to ensure that operational aspects of JTC 21, they support delivery, for example, in time. And there we have the flex process, so we can speed up processes, of course, for the operational items. What I could mention is that we did, for example, for conformity assessment, which ensures access to the market, we have been working together with ANSCA for conformity assessment analysis. What are the challenges, the operational challenges for companies and entities which would like to apply conformity assessment and be compliant with the AI Act? And there we took a sectorial approach, we took examples. We found in that analysis, we found some misalignment in the terms, definitions, but we addressed those. So we have brought those to the discussions, and then they are being addressed as we go. And we are also taking the feedback from the Commission on that. Then in terms of interoperability, what we conclude, it's not a conclusion, the technical report showed that we need to have a conformity assessment framework, which is modular, which needs to take elements from the cybersecurity and the data-related frameworks, and then allow companies just to put on top of the existing modules, for example, for quality management and risk management, the specificities which come for quality management and risk management for artificial intelligence systems. And that ensures the horizontal interoperability. Of course, this is a will. We are developing the standards. And then based on this modular framework, flexible framework, the sectors, they can develop their own conformity assessment schemes. So this is what it's more work in progress, but this is the work that we have done in the technical report. So we assessed, during the time that we're waiting for the AI Act to be finalized, we assessed what will be the challenges for the market, for the European market, according to the European needs. Thank you.
Thank you very much. We are reaching the end. I can see there are additional questions, but we also know there is lunch, and we agreed as a panel that it was not advisable to run over the lunch, although we started a bit later, but please don't hesitate to approach the panelists on your way to lunch. Thank you very much. Thank you very much to the panelists. Thank you very much for your participation. And I would like to thank very much my colleagues, Anya and Camille, for supporting the organization of this wonderful panel. Thank you.